Good evening, everyone. Today, we have gathered together at Legal Savior to discuss on the topic confidentiality in third-party funding in international commercial arbitration. This session for today would be taken up by Mr. Gururaj Devarhubli. Now, Mr. Gururaj sir is assistant professor at Institute of Law, Nizma University, and also pursuing his PhD, and he is a research scholar at GNLU, Gandhinagar. Now, without taking much time, we would proceed further with the webinar of the day. And Mr. Gururaj, welcome, sir, to the Legal Savior. And now you may enlighten all the participants. And this would be a recorded version, so you may deliver your lecture accordingly. Thank you.
Thank you, Sagar, and thank you, Legal Savior, for giving me this opportunity and inviting me for this lecture. Now, the topic which I'll be talking about today is confidentiality in third-party funding. Now, it involves two new concepts which are new for the Indian arbitration regime. First is the third-party funding, and the second new concept which it encompasses is confidentiality. Now, as I think as it is being recorded and also being streamed live on some social media, so as most of the people who are from law background and who have studied arbitration, ADR, one of the things or one of the advantages which is told to them over litigation, which arbitration has, is that it is confidential in nature. There are several other advantages as well, that it is less formalistic, it is less expensive for the parties, there is party autonomy, that the parties can decide the arbitrator, they can choose how to go with the dispute resolution. And these are certain advantages, but one of the advantages which is told to them and which ADR has over litigation is confidentiality, that the parties or the details of the ADR, the proceedings of the ADR shall remain confidential. Now, this is one of the provisions, but is it actual confidential? Is it confidentiality is actually in practice when ADR proceedings are going on? We'll find out in this, and whether a suitable mechanism is required, or there is an actual confidentiality in reality when ADR proceedings are going on or arbitration proceedings are going on. We'll answer at the end of the session. So let me just share the screen here. I hope my PPT is visible to everyone.
Yes, it's visible.
Okay, so the first thing which we'll be talking about, the first new concept, third-party funding. Now, third-party funding in simple terms, let's just have an introduction on it. Third-party funding is the funding of litigation by a party who has existing interest in that litigation with the expectation of returns from the amount recovered as a consequence of the litigation, often without the expectancy to pay in case of failure of the claim. So simple terms, in simple understanding, third-party funding is there is a litigation or any proceeding which is going on, and there is the parties to the litigation or the parties to the case. There are two parties. So one of them or both of them, they receive funding from a third party. Now the third party is a person who is not related, who is unrelated to the case, who is unrelated to the parties, and who is unrelated to the dispute in the matter. So he's funding it, he's funding the dispute because he has some monetary expectation from it. This means when a party approaches a third party funder, third party funder, so this means that the third party funder will not only give certain funding to the party, but he will also expect something in return. And what it is, he expects that if the proceeding, if the decision of the proceeding, or if the award, when we apply it in arbitration, if the award of the ADR or arbitration is in favor of the party who is being funded, then if any monetary award has been given by the arbitrator, if the monetary award has been passed in favor of the party, then out of that, some portion would be kept by the third party funder. These are certain arrangements which are done between the party and between the third party funder. So when a third party funder, when a funder is supporting a party financially, he does not only finance it, he also expects something in return from the party in return. So it can be either some monetary compensation or some other benefit while enforcing the award. So it can be any particular thing. So that is what third party funding is. Now, what all costs are covered here? What are the various points which are covered in the funding? It covers the party's fees and other expenses along with costs and securities. So if there are any securities which are to be given, or if any cost which the party has to bear, all this shall be taken care of by the third party funder, and it shall be covered in the third party funding. However, when we talk about third party funding, there is no universal definition or universal understanding as to third party funding, because each country and each jurisdiction have understood it in their own understanding, and they have expanded their scope as per their national legislations. So, however, there is one definition which I found, and I think that can be applied, that can be considered as a universal one, and that can be applied by the countries in the national legislations. The definition is provided by the ICCA-QUEEN Mary Task Force, and in their report, there was a report which was basically where they studied third-party funding, and in this report, which was published in 2018, they said that third-party funding refers to an agreement by an entity that is not a party to the dispute to provide a party, an affiliate of that party, or a law firm representing that party funds or other material support in order to finance part or all of the cost of the proceedings, either individually or as part of a specific range of cases, and such support or financing is either provided in exchange for remuneration. So as I said, that in exchange of the funding which is being provided, there should be something which should be provided to the funder as well. It can be either remuneration or reimbursement that is wholly or partially dependent on the outcome of the dispute, or provided through a grant or in return for a premium payment. So this can be anything. Whatever funds have been provided by the funder, in return, the party can either reimburse the third party funder by if the decision has been passed in his favor, then if the award has been given, and if any monetary award has been passed by the arbitrator, then in that case, a part of which the expenses which have been borne by the third party funder throughout the proceeding shall be returned or shall be reimbursed to the third party funder by the party, or there can be some any arrangement, or if any remuneration which has been which has to be paid to the third party funder, that can also be paid, or a part of which 50% or 75% of which has to be paid to the third party funder. So there can be various arrangements with respect to third party funding. Now, the definition, the report also defined who is a third party funder. The definition said, third party funder refers to any natural or legal person who is not a party to the dispute, but who enters into an agreement either with a party, an affiliate of that party, or a law firm representing that party in order to provide material support or finance part or all of the cost of the proceedings, either individually or as part of a specific range of cases. So the support, the funding can be done either individually as to an individual case where the funding is to be provided, or for a specific range of cases. If the party is involved in various cases, or he is involved in various disputes, then for each cases, for a specific range of cases, the funding can be provided. So it can be in any way. And such support or financing is either provided in exchange for remuneration or reimbursement that is wholly or partially dependent on the outcome of the dispute, or provided through a grant or in return for a premium payment. So this is what a third party funder is. The person who is providing funding and who is unrelated to the dispute and unrelated to the party to the dispute, that would be known as third party funder. Now, one of the new concepts, another concept, when we talk about third party funding in India, there is no such specific provision under the Arbitration and Conciliation Act which recognizes third-party funding. However, when we see the Code of Civil Procedure (CPC) of 1908, we'll find out that there are certain state amendments which have been done, and certain states in India have recognized the concept of third-party funding in civil proceedings, like the state of Maharashtra, Gujarat, Madhya Pradesh, and Uttar Pradesh. These are the 4 states which have recognized third-party funding in civil suits, in civil proceedings. However, when we talk about third-party funding in arbitration, the concept is still new and it has not been adopted in India under the Indian ADR regime. Now, when we talk about certain developed ADR regimes like Singapore, Hong Kong, they have adopted and they have also regulated third-party funding. They have enacted specific legislations talking about third-party funding and the conditions which are to be fulfilled for third-party funding. There are certain conditions which are to be fulfilled by the parties, and then only they would be eligible for getting third-party funding. Now, it also provides that these jurisdictions also provide who can be a third-party funder and what shall be the responsibilities of the third-party funder, and what shall be the responsibility with respect to the party who is receiving third-party funding. Now, when we talk about third-party funding, the concept of third-party funding is not new in India. As I said, it has been applied and it has been allowed in civil proceedings. Now, one of the committees which was established in 2018, the name of the committee was Shri Krishna Committee, and which was basically set up to understand the arbitrability of disputes in India. Now, this committee made an observation in the report that apart from arbitration legislations in certain jurisdictions, the enactment of supporting legislation has contributed significantly towards the growth of these jurisdictions. These jurisdictions are basically the jurisdictions of Singapore and Hong Kong, where third-party funding is already legalized and regulated. For instance, Singapore has recently passed amendment to its civil law legalizing third-party funding for arbitration and associated proceedings. Similarly, Hong Kong recently legalized third-party funding for arbitration and mediations. The Paris Bar Council has also indicated its support for third-party funding. So this means that there is support and there is regulation of third-party funding with respect to arbitration. However, in India, the concept is still new, and the Indian ADR regime is still adjusting and still accepting third-party funding with respect to arbitration. Now, in that, another issue which which is necessary to be addressed by the legislators when they are legalizing third-party funding. Let's suppose after 1 or 2 years, if the Parliament passes a new provision, it includes a new provision, or it passes a law that third-party funding can be done in ADR proceedings or in arbitration, then in that case, one of the issue which they need to address is with respect to confidentiality. Now, how are these two terms connected here? Let me just give an example. When, for example, if the third-party funding has been legalized in India, now, when the third-party funding is done, or there is a third party who is funding the arbitration proceeding, and the party which is receiving the funding, he has to make certain disclosure. He would be making certain disclosure to the third-party funder, right? When a party is receiving certain funding for covering the cost of the proceedings, covering the cost of other evidences and witnesses, all this is being done by the funder. Then in that case, to receive the funding, to first of all, to receive a fund, for example, if I am the funder, if one of the party, I am supporting one of the party, then that party should disclose to me that what is the nature of the dispute, who is the other party, and what are the chances, the arbitration agreement, what are the contents of the arbitration agreement, and what violation has been done. So all this should be disclosed to the funder. Now, when we say that third part or arbitration is confidential in nature, there can be a provision where it is written, first of all, it can be written impliedly or expressly. For example, if we go for ad hoc arbitration, then in that case, the arbitration agreement implies that the parties would keep the arbitration confidential. They go for confidentiality. Secondly, when there is institutional arbitration, the rules of the institution provide that there would be confidentiality between the parties. Now, when third party funding is being done by the party, in that case, it is necessary that certain disclosures should be done with respect to the dispute, with respect to the claim which is being done in the dispute, and what is the exact dispute between the parties, who is the other party, and what are the defenses which they have done, what are the claims which they are making. All this should be disclosed so that the funder exactly knows what are the chances that whether the party who is being funded, ठीक है, सपोज अगर मैं एक फंडर हूं, अगर मैं किसी पार्टी को सपोर्ट कर रहा हूं, ठीक है, if I ask him all the details are necessary because I exactly should know that if I fund him, what are the chances that the amount which I am funding him, ठीक है, जो जितना पैसा मैं इसके ऊपर इन्वेस्ट कर रहा हूँ, whether that would be recoverable or not, whether I can recover it if the outcome is in my favor. ठीक है, if the funder knows कि ये डिसीजन, ये पर्टिकुलर मैटर का डिसीजन जिस पार्टी को मैं फंड कर रहा हूँ उसके फेवर में नहीं है, and he may not win the case, तो then in that case I will not fund that party. I will fund basically the party who is winning, या जिसके फेवर में मैटर, जिसके फेवर में डिसीजन या अवार्ड आने की पॉसिबिलिटी है. Therefore it is a kind of business, इन्वेस्टमेंट की तरह इसको देखा जाता है. Therefore it has to be seen, first of all it has to be understood that when a third party funder is there, he needs certain disclosure should be made by the party to the funder as to the nature of the dispute, the other party who is involved, and what are the chances of winning, so that the funder can know what are the chances of winning or losing this particular matter. Okay? Now when we say that ADR proceedings are confidential, arbitration proceedings are confidential, do you think that would be correct? Because when section 42 has been included now by way of Arbitration and Conciliation Act 2000 Amendment Act 2019, a new provision has been included, which is section 42A under the Arbitration and Conciliation Act. The title says confidentiality of information. Now the provision says, notwithstanding anything contained by any other law for the time being in force. This means that it is a non-obstante clause. Okay? It will override all other provisions. The arbitrator who shall keep confidentiality, first of all, the provision says the arbitrator, the arbitral institution, and the parties to the arbitration agreement. So the responsibility to maintain confidentiality of the information lies on three entities, lies on three parties. First is the arbitrator of the dispute, the arbitral institution, if there is an institution, and the parties to the arbitration agreement. All these people shall keep confidentiality. Okay? They shall maintain confidentiality of all arbitral proceedings. Of all arbitral proceedings. Now the term word which has been used is shall maintain. So this means that it is mandatory for the parties, for the arbiter and for the arbitral institution to maintain confidentiality of all arbitral proceedings, except there is one exception here, except award where its disclosure is necessary for the purpose of implementation and enforcement of award. Now where the award is to be enforced, then in that case the disclosure has to be made. Certain disclosure has to be made for the purpose of implementation and enforcement of award. Now when you see an award, arbitral award, it contains all the details. It contains all the details, the names of the parties, the nature of the dispute, the claims made by the parties, and what is the final decision taken by the arbitrator or the arbitral tribunal. All this is contained in the award. So there is no actual confidentiality as such. If you see in practicality, the provision says that there shall be confidentiality. So it means that there should be absolute confidentiality. Now, the problems with this provision, which I would like to highlight, is first of all, there is a lot of subjectivity which is involved. There is a lot of subjectivity involved. First of all, because except where the award is necessary for the purpose of implementation and enforcement of award. Now, for the enforcement of award, if the disclosure has to be done, then it is allowed. But even in that case, if disclosure is allowed, what shall be the scope of the disclosure? What shall be the scope of disclosure? This means, does the disclosure should include every detail of the dispute or of the parties, or there should be certain details which can not be disclosed or which cannot be disclosed in any case? Is there any particular fact or any other particular matter which is not to be disclosed in every matter or in any case? Because the term used in the provision is shall maintain confidentiality. So this means that it is mandatory for the parties to maintain confidentiality. So this means that there is absolute confidentiality. So, but again, there is an exception. So there is a lot of subjectivity involved here. The first problem with this provision is there is a lot of subjectivity involved. कितना disclose करना है, ठीक है, enforcement के लिए disclose करना है, that is correct. But even in that case, how much disclosure should be done? That is not understood. That cannot be. That is left for the parties to decide. That is left for the institution or the arbitrator. What shall be the scope? How much details should be disclosed? That is for the parties. So again, there is no clear understanding or clear rules as to what can be disclosed and what cannot be disclosed. Okay. Second problem is with the enforcement in India. As I said earlier, कि enforcement करना है तो सारी चीजें disclose होती है. Enforcement of award के लिए या जो award होता है, ठीक है, it contains all the details. Parties का details क्या है, enterprises हैं तो companies हैं तो उनके details क्या होंगे, who are the parties, what is the nature of the dispute between them, ठीक है, and if the matter has been already decided, अगर वो interim measure के लिए आया है या it has been went for appeal, ठीक है, all these are details, all these details are contained in the award. So again, there is a problem when we are disclosing something for enforcement of an award. The award contains everything. So again, there is the confidentiality problem or the confidentiality requirement is not satisfied there. Second, contents of award. Next point, which problem with the provision is section 42A is the contents of award disclose everything. अगर मुझे disclose करना है and if I have to give a copy of the award for enforcement purpose, ठीक है, and I do not disclose anything orally, but the award would disclose everything. So there is again no confidentiality as such. Absolute confidentiality. This is a question which I would like to ask because, and which I have in my mind when I saw this provision, because there cannot be absolute confidentiality. Because if there is a dispute which involves certain public interest, then in that case disclosure can be required. Disclosure, the exception would be applied and the disclosure can be done. But again, what kind of disclosure and how much disclosure should be done, that is not understood. Again, when private interest is involved, the dispute is relating to a particular party or a particular individual, then in that case, what shall be done? What shall be the, how shall be the provision be applied? That is also not understood. Now, the provision, if we see, the provision simply says that there shall be confidentiality by the parties, by the arbitrator and by the arbitral institution, and they shall maintain confidentiality. The requirement of confidentiality is provided. But what if the confidentiality provision has been breached? Section 42A provides for confidentiality in arbitral proceedings by the arbitrator, by the arbitral institution and by the parties. But if the provision has been violated, agar iska breach hua hai, then what shall be the punishment? That is not provided here. Okay? So the next problem is section 42A enough? Is section 42A enough? Because based on a single provision, relying on a single provision, you cannot maintain confidentiality. There should be something else by way of backing, by way which should support this provision, or which should be included in the provision itself, so that it has a legal backing, it has a deterrent effect. अगर violation हुआ section 42A का, then what shall be the effect? वो clear नहीं है, ठीक है. So if any party has disclosed to some other person, again जो मैंने problem बताया कि किसी भी person को disclose नहीं करना है, the party shall not disclose it to anyone, ठीक है. Now whether it would be covered by both the parties, whether it would be covered with respect to third party funder also, because third party funding as such is not accepted or is not uh, as such allowed in India with respect to arbitration. It is not a concept which has been uh, which is not much prominent with respect to arbitration. So when we are talking about third party funding, when we are talking about confidentiality, whether confidentiality would be covered with respect to the disclosure done uh, by to the third party funder also, whether the parties would be required to follow this provision section 42A even if they are disclosing it to third party funder. So ये जो disclosure है, confidentiality का provision है, whether it would cover third party funder also, that is also not understood. ठीक है? And if there is a situation, let's suppose there is a problem, yeah, there is a proceeding जहाँ पे दोनों parties arbitration के लिए जाते हैं, and the funding party or the funding agency is the same. Both the parties are receiving funding from the same funder. Then in that case, what would be the problem? Because दोनों को एक दूसरे के बारे में पता है, funder knows both the parties, ठीक है? Funder is supporting both the parties. Then in that case, whether confidentiality would be maintained, whether it would be breached or not. So these are certain problems which are I do not have a proper answer for that, but कुछ problems ऐसे हैं जिसका answers I can give. Like for example, अगर breach होगा तो क्या होगा? ठीक है? As I said that if there is a breach of section 42A, what can be done? There can be award of damages award हो सकता है. ठीक है? That can be the only thing which can be done. But in actuality, when we see in practical life, जब ये कोई केस आएगा जहाँ पे सेक्शन 42A डिसाइड किया है, ठीक है, the scope of section 42A has not been decided as such by the arbitrator or by the Supreme Court, ठीक है, even the penalty or the punishment for violation of section 42A is not provided anywhere, neither in the legislation nor by the Supreme Court, ठीक है, कोई भी rules as such laid down नहीं किए. Now when we understand the position, international position with respect to third party funding under the IBA guidelines on conflict of interest, ठीक है, rule 6B provides that a direct economic interest in or a duty to indemnify a party for the award to be rendered in the arbitration may be considered to bear the identity of such party. Second says a direct economic interest and can be considered as equivalent of a party to an arbitration. So this is what is relevant for us. The second part, a direct economic interest can be considered as equivalent of a party to an arbitration. So it covers third party funding in some way. But when we talk about India, there is no specific provision except for the CPC, जहाँ पर third party funding is allowed by the states of Maharashtra, Gujarat, Madhya Pradesh and Uttar Pradesh with respect to civil proceedings. But the concept of third party funding in arbitration or in ADI proceedings is still new. It has not been allowed or it has not been regulated as such. Now, when this concept is still new, accepting or allowing confidentiality in third party funding, it has also its own problem. As I said, the problems with respect to section 42A, okay? Apart from third party funding, the confidentiality provision as such has certain problems in it. What shall be the scope of confidentiality in case? Can there be a standard which can be laid down as to confidentiality, or it would depend on case to case basis? That is also a problem. So with this thought, let me just conclude my presentation. It is usually said that transparency is ethical, because whenever we are talking about ADR or when we are talking about arbitration, it is necessary that there should be transparency with respect to the proceedings, with respect to the schemes which are being adopted by the parties. There should be transparency between them. Then only the ADR proceeding or the arbitration proceeding would be fruitful for both the parties, because ADR is something, one of the features of ADR is that it provides a win-win situation for both the parties. All the parties are winning, so there is no one is losing. So therefore it is different from the litigation, where litigation only one of the party is benefited. जिसके फेवर में अवार्ड आया है, जिसके फेवर में डिसीजन आया है, that party has benefit. जिसके फेवर में नहीं आया, it is at disadvantage. But the feature of ADR or arbitration is that it provides a win-win situation for both the parties. Therefore, for providing this win-win situation, so that there can both the parties can benefit from the proceeding, there should be transparency. There should be transparency between them. But the statement which is usually done, and then also there should be confidentiality. There should be transparency and there should be confidentiality as to the proceeding from any third person. So there should be transparency between the parties and confidentiality by the parties with respect to third persons, so that they do not disclose the identity, they do not disclose the matter which is being resolved through arbitration to the any other third person who is not a party to the dispute. But a statement which is usually done is transparency is ethical. It is a principle which is ethical in nature. By way of ethics, transparency should be there. But when we are talking about confidentiality, confidentiality is suspicious. Confidentiality is suspicious because the parties may not always remain or may not always maintain confidentiality. There is something by way of orally or by way of any telephonic communication, telephonic conversation, they can disclose something about the proceeding or something about the arbitration which is being going on. So therefore it is said confidentiality is suspicious, and also the provision of section 42A has made it more suspicious because there is still no clarity as to how much confidentiality should be maintained and whether confidentiality is absolute in nature or is it allowed in some case. The provision says that it is allowed for the implementation and enforcement of the award. But again, how much disclosure should be made, how much confidentiality should be maintained for enforcing the award, that again is still a question. So my suggestion or my recommendation would be that the parliament should provide more clarity as to confidentiality with requirement to the confidentiality, and they should also analyze that whether the requirement of confidentiality would be mandatory or it would be discretionary on the parties when they are seeking third party funding. So with this, I complete my presentation. As it was a very new topic, so I did not have a much discussion on this because it's still new in India. The concept is still new. Therefore, I did not include much time on this. So with this, thank you for patient listening, and I'm open to any questions which anyone have.
Yeah, thank you very much. Actually, though the topic is very new, but the content that you shared was pretty apt because it covered all the areas and avenues as of now what is included in this topic. And we are expecting some questions. Is there anybody who have joined having any questions? If not, that I may ask. My query is that I agreed to the fact that there should be confidentiality maintained in the funding aspect of this international commercial arbitrations more particularly. But as of now, the present era is of openness, like everything is shared with public. Even the companies who are engaging into major deals of commercial nature is also making a public statement. So in that scenario, what is your opinion?
In that case, my opinion here would be that parties should maintain confidentiality. That's why even in recent times, when you're talking in today's world, the amendment has still been made. In today's time, where the concept is that everything should be open, the disclosures or the statements are being given in public. But even now, even then, the Arbitration Act was passed in 1996. It was enacted in 1996. The requirement for confidentiality, the provision of confidentiality was included by way of amendment in Arbitration and Conciliation Amendment Act 2019. So this means that confidentiality should be there. Confidentiality is better, and it is the best for the with respect to ADR for the arbitration. But again, with respect to confidentiality, how much confidentiality should be there, the scope of confidentiality, there is still no address which has been done by the parliament or by the judiciary on this. Because the trend which has been done in other countries, in other jurisdictions, is they enforce confidentiality. They enforce confidentiality on the parties with respect to the identity of the arbitrator. Even the identity of the parties, if you see, is not disclosed. For example, if you see some cases of Hong Kong and Singapore, the name of the case is like A or A versus B, X versus Y. So the name of the party is also not disclosed. So in that case, where if we see in India, the name of the party is clearly disclosed, even they go for arbitration. So this means India is walking on that particular path where they are going for confidentiality, they are adopting confidentiality, but it has been only done by, it cannot be achieved by including only a particular provision. With the mere support of section 42A, confidentiality cannot be achieved. There should be something else which should be backing the provision, either any punitive measures or any other guidelines which can help the parties, which can help the arbitrator as to how much confidentiality should be maintained. And there should be some other mechanisms by which confidentiality, the parties should know that how confidentiality can be maintained.
Yes, very
I
well.
hope I answered your question.
Yes. In light of section 42A and what is practically going on right now, it was precise. And I hope there is no other questions of the participants. And if there is any after the completion of this webinar, they may write to us. And I, Legal Savior, Mr. Gururaj, we all will connect together and try to resolve the queries of any of the person with regard to this particular topic, if any. So, Gururaj sir, it was wonderful session. We have connected earlier too, and this was very precise. Like we have made the module of the nature that we are discussing these very big topics in very limited time frame and discussing only the relevant points. So anybody making revision or just brushing up the things can do it very easily. So having discussed all these aspects, now I would once again thank you, Mr. Gururaj Devarhubli, to join us, and I hope to see you again at Legal Savior. It was wonderful to have you here. Thank you very much, and we would be concluding now. Thank you.
Thank you for the session and the invitation. I hope I have given you some information on this particular point, because as it is a new topic, I hope some students who are present here and who are watching us on YouTube and Facebook, they would be gaining some knowledge, and they hope, I hope that they write a particular article or they do some more research on this topic. If they have an interest in ADR.
Yeah. Okay. Thank you.
Thank you, Sagar and Legal Savior, for the invitation.
Thank you.